Today, we're going to dive into a fascinating story from legal history. It's all about a simple agreement for European vacation that, believe it or not, ended up changing the rules of contract law forever. And it all happened because of a promise that was broken just a little too early. So let me start with a question for you. Can you actually break a promise before it's even time to keep it? I mean, think about it. Imagine someone promises to pay you for a job next month, but today they call you and say, yeah, I'm not going to do that. Have they technically broken the promise yet? Can you do anything about it now? Or do you have to just sit around and wait until next month when the money is officially late? This exact puzzle is what our story is all about. To get to the bottom of this, we've got to go back in time. Way back. We're talking London 1852. Picture it. Bustling Victorian streets, a huge center for business and travel. And right there, a seemingly simple deal is about to create a legal mess that the courts had never really dealt with before. Our story kicks off with something called a grand tour. It was this big rite of passage for the wealthy back then. And this all started with a simple agreement for what was supposed to be a very big journey. Now, this whole conflict really boils down to just two people. On one side, you've got Mr. Hochster. He's an experienced professional courier. This is his job, his livelihood. On the other side is Mr. Delatour, a wealthy guy planning a big 3-month trip around the continent. The deal itself seemed crystal clear. In April, they agreed that Hochster would start his job as Delatour's courier on June 1st. He'd guide him through Europe for 3 months. So Hochster stops looking for other work, and Delatour has his expert guide locked in. Seems simple enough, right? What could possibly go wrong? Well, as you've probably guessed, the plan completely changed. A promise was about to be broken, and the timing of that break, well, that's the crucial part of this entire story. Okay, so let's walk through the timeline, because this is key. In April, the contract gets signed for a June 1st start date. But on May 11th, weeks before the job is even supposed to begin, Delatour writes a letter and just cancels. And check out what Hochster does. He doesn't wait around. He sues on May 22nd. Think about that. He's suing before June 1st, the day his work was supposed to start, has even arrived.
And this wasn't some vague, I might have to cancel situation. Delatour's letter was completely final. He basically said, the deal is off, go find another job. That very clear statement would end up being a critical piece of evidence.
This put Hochster in a really, really weird position. He had a contract, sure, but the day he was supposed to start work was still weeks away. So could he actually sue for a problem that technically hadn't even happened yet? To get why this was such a dilemma, you have to understand the law back then. Traditionally, a breach of contract was really simple. You fail to do what you promised when you promised to do it. If a delivery is due on Friday and it doesn't show up, that's a breach on Friday, not before. And that was the core legal question here. Delatour's lawyers argued that he couldn't possibly be in breach of contract because, well, June 1st hadn't come and gone yet. As far as they were concerned, Hochster had jumped the gun. He was way too early. And under the old rules, you know what? They were probably right. The law as it was would have forced Hochster into this absurd waiting game. He'd have to just sit there, unemployed, unable to take other jobs, all the way until June 1st. Only then, after Delatour officially failed to start the trip, could he sue. Imagine how impractical that is. It just made no sense. But thankfully, for Hochster and really for all of us, the court decided to look at this whole thing with fresh eyes. And its decision would become a true landmark, a game changer in contract law. So how did the court get there? Well, its logic was pretty groundbreaking. First, they just looked at reality. Delatour's letter wasn't a maybe, it was a definite, I'm backing out. Second, they recognized how deeply unfair the old rule was. It punished the innocent guy, Hochster, forcing him into this weird limbo. And finally, they realized the law itself was just missing something. It needed a new rule to handle this exact problem. And so the court sided with Hochster. They ruled that his lawsuit on May 22nd was perfectly valid. And in doing that, they didn't just solve one guy's problem, they actually created an entirely new legal doctrine. They called it anticipatory breach. Now, it sounds a little fancy, but the idea is actually simple and really powerful. It says that when one person makes it absolutely clear that they are going to break their promise, the other person doesn't have to just sit there and wait for the disaster. They can treat the contract as broken right now and take action immediately. So why are we talking about a 170-year-old case with a tour guide? Because the rule it created protects all of us in countless situations today.
I mean, think about how this applies to your life. A client tells you in March that the huge freelance project you had lined up for July is canceled. Because of this case, you can act now. A future tenant signs a lease for your apartment but then backs out before move-in day. You can start looking for a new tenant right away. A company takes back a job offer after you've already accepted. A supplier confirms they can't deliver that future order. All of these situations are covered. Here's the key takeaway. Because of this case, Hochster versus De La Tour, the law gives you the power to be proactive. You have the right to limit your damages, to find that new job, that new client, that new tenant, without just waiting helplessly for a date on the calendar to pass. It's a common-sense solution to a really frustrating problem.
The judge in the original case, Lord Campbell, he summed it up perfectly. He said that the person who wrongfully breaks the promise first, well, they can't really complain if the other person takes them at their word and sues them right away. It's just a powerful statement about fairness. And so we end up right back where we started, but now we have an answer. Thanks to a courier and a tourist back in 1852, the law now recognizes that the damage from a broken promise doesn't start on the day it was supposed to be kept. It starts on the day you find out it never will be.